hoping that you should be able to see the slides on the screen now. I see a nod or two, which I'm grateful for. So I'm going to take that as you're able to see these slides. So the topic areas that we're going to cover today are highlighted on this slide. As I said, I'm going to deal with one case under each of those different topic areas and then highlight a number of important cases from each of those areas. All right, so let's go straight into the first topic, and that's the topic of hourly rates. Of course, a very significant issue for any costs practitioner or indeed civil practitioner generally. Now, it probably won't come as too much of a surprise to people that the case that I've chosen to highlight is the case of PLK, a case that was much heralded in the legal press and is a case that is of some significance for reasons that we will come on to. Now, dealing briefly with the background to PLK. So in PLK, the applicants were solicitors dealing with court of protection at work. And a number of solicitors came together and made an application to ask the Senior Court Costs Office to deal with the principle of the method of assessing the hourly rate. The case had 4 firms, and in each of those firms, they sought a 31% uplift to the hourly rate based on overheads that they said were specific to court of protection at work and also the complexity of the claim. Now, Master Whalen dealt with the case and he set out the ordinary approach to dealing with court of protection bills. He acknowledged that since 2007, for those dealing with court of protection work, the bills are ordinarily assessed on the basis of the guideline hourly rates. So that's the Summary Assessment Guideline Hourly Rates 2010. The court would ordinarily set out the grade and also the correct bracket, so both the location and the specific fee earner. Now, the applicant set out 2 broad submissions. The applicant said, firstly, the approach that is taken at the moment is wrong because the court should not slavishly follow the guideline hourly rates. Instead, the court should do what perhaps it does on detailed assessment, which is that the court should look at the factors that are set out in CPR 44, take into account the specialised nature of the work, and also take into account the overheads that they highlighted for court of protection at work. On that basis, the court should then apply an increased hourly rate. Alternatively, the applicant said, well, if you aren't with us on that, then the approach that you should take is to use the guidelines as your starting point, and you should then apply an uplift to the guidelines, and that should be at 31% in line with RPI inflation. Now, in reaching a decision on that case, the master made 2 observations. The master said, firstly, given that this is a court of protection issue, there is an important principle of certainty that has to be taken account of here. And that principle requires practitioners to have some certainty and consistency in the way those rates are going to be assessed. Because, of course, the pot from which the deputies will seek those costs will be very often the pot of damages. And so practitioners will need to be aware when calculating the damages what those costs might be with some degree of consistency and certainty. And the second point that was made was a practical point concerning the manner in which these bills are assessed. Master Whalen said those bills are assessed effectively in every case by a cost officer, unless that cost officer refers it to a cost judge. They deal with over 8,000 bills each year. And whilst those cost officers have significant experience, they may well not have the experience that's required judicially to weigh up the factors in CPR 44. So those were the two observations. Master Whalen also made the point in respect of inflation that just as the application of the guideline rates may be somewhat arbitrary or a blunt instrument, so would the application of inflation simply at 31%, that would also be somewhat of a blunt instrument. But, and this is the important point that comes out of PLK, Master Whalen acknowledged that the guideline rates cannot be applied fairly and equitably as an index of reasonable remuneration unless they are subject to periodic review. And quite clearly, those rates have not been subject to periodic review. These are 2010 rates, and whilst there was some attempt in 2015 to look at this issue, the rates have not been changed since that point. So on that basis, Master Whalen gave a direction to the cost officers that if the rate claimed was within 120% of the guideline rate, then it would be considered to be prima facie reasonable, and outside that bracket, it would be considered to be prima facie unreasonable. Now, of course, there are specific considerations here that apply only to court protection at work. But there is a wider point that it seems to me is of importance for inter partes detailed assessments. And that regards the unsatisfactory nature of the current guideline hourly rates. And certainly Master Whalen, an experienced master, very familiar with dealing with inter partes assessments, was of the clear view that to apply these rates equitably, they must be subject to periodic review. Now, interestingly, and as is often the case with these things, about 2 days after I'd finished my slides, a further case came out dealing with hourly rates. And that's the case that I highlight on the next slide of Harvey Cohen and Marion Fine. This came out about 2 or 3 days ago. It was a business and property case, but a similar point was made, as was made in PLK, regarding the inadequacy of the guideline rates. And the point that was made in Cohen and Fine is that in the judge's experience, the rates that were being charged, again in the context of business and property, by the solicitors in the Northwest and London, was significantly out of step with the current guideline rates. The judge was of the view that those rates should be subject to at least an increase that takes account of inflation. And so in this case, in Cohen, the judge increased the rates by 35%. Now, that is, of course, not to say that that will necessarily apply to the wider range of personal injury at work, but certainly it is a point that seems now to have a number of judicial comments regarding the inadequacy of the 2010 rates, and perhaps importantly in Cohen, the rate was increased for all grades of fee earner, not just the fee earners with primary control of the litigation. So that was PLK and also Cohen, important cases dealing with issues concerning the hourly rates. So let's move on to qualified one-way cost shifting, our second topic. Now, I have to say, this isn't many people's favourite topic, a topic that certainly causes significant difficulty for practitioners. Now, I expect that most people here will be familiar with the operation of qualified one-way cost shifting. In case there are those who are not, very briefly, it is the principle by which a defendant is limited in the enforcement of their cost order to the level of the order for damages and interest, the aggregate of the two. Of course, things are not always as simple as that simple principle, as we find out from the case of Ho and Adelaken. Now, I probably could refer to this as Ho and Adelaken Part 2, because many of you will be familiar with the first decision in Ho and Adelaken, which was a significant decision last year dealing with fixed costs disputes. And in Ho and Adelaken Part 1, we had an issue regarding whether the claimant was entitled to standard basis costs to be assessed, or whether in fact they were only entitled to costs that were fixed. So that was the issue that we had to deal with in Ho and Adelaken Part 1. Now, looking at the background of the case, this was a personal injury claim. The defendant made an offer by way of Part 36 to settle for £30,000. It was a claim that was allocated the fast track, but the parties agreed that the case should be reallocated to the multi-track. Unfortunately, an offer was then accepted prior to the reallocation taking place, which significantly complicated matters. And the offer that was accepted provided, by way of a Tomlin order, that the defendant was to pay the costs on the standard basis to be subject to detailed assessment. So, said the claimant, on the basis of that, this was a case which should attract standard, not fixed costs. The defendant disagreed, and ultimately the defendant was successful in the Court of Appeal, and the claimant was limited to fixed costs. So that was the position that is underlying the Ho and Adelaken Part 2. So the result of the Court of Appeal's finding in Part 1 was that both parties had a cost order. The claimant was entitled to the costs of the personal injury claim, and the defendant was entitled to the costs of the appeal proceedings. And so on that basis, the defendant said, well, not only are we entitled to set off our cost order against damages, we're entitled to set off our cost order against your cost order. And they base that on CPR 4412. 4412, which provides in terms where a party entitled to costs is also liable to pay costs, the court may set off the amounts assessed. And the respondent, here the claimant, said no, you're not entitled to do that because CPR 4412 is in Part 1 of CPR 44. And the qualified one-way cost shifting provisions are in Part 2. And Part 2 is a self-contained code. And you're not entitled to rely upon something outside that self-contained code. The problem the claimant had in this case here was the decision of how. A decision that, in fact, was a decision of the Court of Appeal, unreported, in fact, dealing with this question of whether, in a Quats case, a defendant is entitled to set off costs against costs. Now, the claimant said that Howe had been decided per incuriam, but that, of course, relies upon the claimant being able to demonstrate that there is a contrary rule or a statutory rule or other rule that the court ignored or did not take into account at the time the decision was made, and the Court of Appeal was against the claimant in a finding that the decision was per incuriam. But that wasn't the end of the matter as far as the claimant was concerned, and perhaps as far as practitioners are concerned, because it's fair to say that the Court of Appeal expressed reservations on the decision in Howe, and perhaps fairly serious reservations on the decision in Howe. In fact, when one looks at the judgment, one sees, particularly from Lord Justice Newey, an indication that but for the decision in Howe, he would have accepted that the claimant was in fact protected by Quox, in that the defendant was not entitled to set off costs, Quox being a self-contained code. So there were fairly serious reservations that were expressed, but ultimately the Court of Appeal were bound by the decision in Howe. And so an order was made that costs could be set off against costs, and there was whilst there was a discretion as to whether that should be ordered, once it had been determined in principle that the court could order that, the Court of Appeal found no reason in Howe and Adelaken not to. Now, the implications of the decision are significant for it means that not only are there damages potentially at risk from deduction, but also the costs are at risk of deduction. And for a defendant, it is, of course, a powerful tool for a well-placed Part 36 offer in a case where perhaps the damages mean that it would not fully compensate them simply for a offset or a set-off against damages. So it's an important and significant decision. It's a decision which is going off to the Supreme Court and likely to be resolved by them, if not by the rule drafters. Both Lord Justice Newey and Lord Justice Mayles indicated in Howe and Adelaken that this was a point that the rule drafters should consider. So we will see what may happen with this. But certainly it causes a headache for practitioners prior to any resolution of this issue by the Supreme Court or the rule drafters as to exactly what should be done in the intervening period. Certainly, one will see with increasing frequency claims by defendants to set off costs against costs, and it's an issue that certainly is going to have to be actively considered by practitioners, whether or not there is scope for this issue to effectively be stayed or held over pending the determination of that appeal. And certainly that is a point that I know is a point that many will have to actively consider when dealing with what is a headache that has arisen from Howe and Adelaken. So that's the decision in Howe and Adelaken, an important one and one for everybody to be aware of. I've highlighted two other cases from the Quox section. I'm going to deal with these briefly, but Wixon Building Supplies and Blair, it's an interesting and important case for those to be aware of. It's a case that really determines that Quark's protection continues to apply to the appeal process, both first instance and subsequent appeal. We previously had some authority in Parker and Butler dealing with this particular point, but it is useful to get to the Court of Appeal to determine that particular point. So we now have Wicks Building Supplies and Blair. Waterfield and Dentality, perhaps a bit more of a niche case, a fairly recent one, but one that's worth highlighting in any event. And Waterfield and Dentality dealt with the issue of whether Quarks applied to a pre-issue application for a group litigation order. Those orders, of course, can be sought both pre and post issue, but in Waterfield it was sought pre-issue. And so the court was asked to look at the definition of proceedings and whether or not that meant that Quark's protection applied or did not. And in Waterfield, the judge determined there are no proceedings, and therefore, in fact, Quark's protection doesn't apply, and made the point that if the group litigation order had been sought after proceedings had been issued, then in fact Quark's protection would have applied, but not to the pre-issue application. So that's Waterfield and Dentality. Now, Part 36 and other offers a topic area that certainly never fails to generate significant dispute. I could have highlighted perhaps 10 cases in this topic area that are important, but I've had to be selective and choose one. But I've highlighted a number of others as well for you. But the case that I've chosen to focus on is Telefonica, UK and the Office of Communications. Now, dealing briefly with the background to Telefonica, it's a high-value piece of litigation which relates to the license fees that mobile phone operators paid to Ofcom between 2015 and 2017. Now, these payments were made pursuant to a regulation which set the level of that fee. So far, so good, until the regulation was quashed by judicial review. So the result was a claim by the claimant for restitution, and the issue to be determined was the proper amount of that restitution. Now, the sums, I have to say, are fairly eye-watering. The claimant sought 54.38 million, and it made a Part 36 offer of 52.82 million. And at trial, the claimant was awarded the full amount of the claim. And so the result of that was that they'd beaten their own Part 36 offer. So the cost issue to then be determined related to the enhancements in CPR 3617. Now, most of you, I am sure, will be aware that where a claimant beats their own Part 36 offer, there are a number of enhancements which the court may award. There are 4 set out in 3617 subsection 4. The first is interest on the whole judgment at a rate not exceeding 10% above base rate. Secondly, costs on the indemnity basis. Thirdly, interest on those costs. And finally, an additional sum calculated on the damages, but not exceeding £75,000. And when the court is asked to look at those enhancements, it's asked to look at whether or not it's unjust to award them. And there is a list of factors set out in 3617 subsection 5, which the court can consider when it's looking at whether it would be unjust to award the enhancements. So that includes issues such as whether it was a genuine offer to settle, what was the information available to the parties at the time of the offer. Now, at first instance, the court decided that it was going to award the enhancements, but only some of those enhancements. So it awarded the £75,000 as an additional sum, and it awarded indemnity costs, but it refused to award enhanced interest on either the damages or costs. And given the sums at stake, the interest in this case ran into the millions of pounds. So it certainly was not an issue without consequence. So that was the first instance decision. Now, the Court of Appeal was asked, well, is it possible for the court to award some, but not all of those enhancements? And in principle, yes. They confirmed it's possible for the court to order some, but not all of those enhancements. But they made an interesting observation, which was that it should be an unusual case in which some, but not all of those enhancements actually apply. And in Telefonica, the court had as its starting point the fact that the judge had not considered it unjust to award some of the enhancements. And so the issue became, well, if it wasn't unjust to award some of the enhancements, what made it unjust to award all of the enhancements? And a number of factors were looked at. One was in respect of whether this was a genuine attempt at settlement. This was an offer that was only modestly, not modestly perhaps in terms of monetary amount, but in terms of a percentage, modestly below the final, the maximum total of the claim. And so the question was, well, is it a genuine offer of settlement? And in Telefonica, the Court of Appeal said, well, clearly the judge decided it was because he awarded some of the enhancements. So that wasn't a point that was open to be argued. The second issue the court looked at was whether one could argue that the claimant had only exceeded their offer by a modest amount. Would that be a reason to deprive the claimant of the enhancements? No, said the Court of Appeal to that, because that would be to reintroduce Carver into Part 36, which would not be appropriate. And finally, the court considered whether or not the awarding of some of the enhancements may make it disproportionate to then award the others. And perhaps that might be a reason not to award all of the enhancements. And again, that approach was rejected by the Court of Appeal, the Court of Appeal finding that once it had been determined that some of the enhancements should be awarded, it wasn't then open to simply say, well, I've awarded some of the enhancements, it's now disproportionate to award the others. And on the question of proportionality, the court again made the point that when dealing with a topic such as interest, it's open to the defendant and the court to reduce the rate of interest to a rate that may be considered to be more compensatory rather than punitive, to address any proportionality concerns as to the extent of the enhanced interest that might be awarded. So it's an important case. It clarifies a number of issues that had arisen in respect of the application of the enhancements in CPR 3617. It's interesting for its observations on Carver, and it's interesting for the general observation that it will be an unusual case in which some, but not all of the consequences apply. So that's the decision in Telefonica. So I've highlighted a number of other cases for you to be aware of in respect of Part 36 and other offers. Swift and Carpenter, which I'm sure most people are aware of for the significance of that case to accommodation claims. But there was a cost judgment which is interesting in itself. The first observation that one may make from this, and you can see this from the slide itself, is the importance of a well-placed Part 36 offer. We see here the claimant exceeded the offer by £1,900 and recovered £65,000 in addition, and also interest of £43,000. But one important and interesting point that came out in Swift and Carpenter was similar to the point made in Telefonica regarding the level of interest. And in this case, the court was asked to look at the conduct of the parties as it may affect the level of interest that was awarded. And broadly, the court, when looking at that, decided against a level of interest that might be very punitive and instead ordered an interest rate of 4.5%. And both parties made reference to various conduct points at which the court weighed in the balance when looking at the level of interest to be awarded. One other point that perhaps comes out of this, if any more confirmation was needed, was an argument as to whether or not the claimant should be entitled to interest as the solicitors were acting on a CFA. That point wasn't accepted as precluding the claimant from obtaining interest. So that is Swift and Carpenter. Essex County Council, again, an interesting case, and perhaps a case which deals with a potential trap for Part 36 offers. And that related to the date on which the offer was made. So in Essex County Council, the offer was made on the 7th of March. And the letter provided that the relevant period in which the offer could be accepted with the normal Part 36 consequences was within 21 days of the date of this letter. So the letter is then dated the 7th of March, and it's sent in the late afternoon of the 7th of March. So it arrives in accordance with Part 6 on the 8th of March. And so the defendant said, well, your offer has a relevant period of 20 days, not 21. Because the letter says that it's within 21 days of the date of this letter. And that's the 7th of March, but you only made the offer on the 8th. Now, the court rejected that interpretation of the offer, but there were two interesting observations that came out of that rejection. The first was that the judge accepted that if he was wrong about that, then he would not accept an argument that the error was de minimis. And the second observation that arose out of that was that the offeree would not be able to rely on estoppel, essentially on the basis that this had not been pointed out at an earlier stage when the offer was made. For on that basis, the offeree should be stopped from being able to rely upon that failure. The court rejected that approach as well. So finding in favour, in this case, of the construction of the offer being a valid offer, but two interesting observations regarding the problem that would have occurred if the court was wrong or found against the claimant on that point. Now, MEF and St George's Healthcare NHS Trust, a case that may come as a surprise to a number of practitioners, and that relates to the point at which an offer could be accepted. Now, here we were dealing with a Calder Bank offer. That Calder Bank offer was made in August 2019. It totaled 440,000, and the detailed assessment was in September 2019. And it became clear during the course of that detailed assessment that the claimant was not, in fact, going to beat the defendant's offer. And so the approach the claimant took is to say, towards the end of the second day, they were going to email the defendant and accept the offer. And that's what they did. And the defendant denied that the offer could be accepted. And that was the point that was in contention. Now, the master found, in fact, the offer could be accepted and was validly accepted. And the basis of that was a number of observations. The first is that this wasn't a Part 36 offer, which would have the normal result that the offer couldn't be accepted after the trial had started without permission. Secondly, the offer hadn't been withdrawn once the detailed assessment started. And thirdly, it didn't contain any time limit. The court also considered it relevant that none of the previous offers that had been exchanged contained a time limit. So all of those points were relevant to the question of whether the offer was in fact validly accepted. So an important case in MEF. King and City of London, I've highlighted. Most people will, I think, be aware of this. And this is the fact that an offer exclusive of interest is not a valid Part 36 offer. It equally applies to detailed assessment. Lejeanbon and Burgess, a final case that I'll highlight on Part 36 and other offers. And that's the question of indemnity costs for defendants where they beat their own Part 36 offer. The point made in Lejeanbon is that the defendant is not automatically entitled to indemnity costs in that situation, but the defendant can, of course, seek an offer for indemnity costs. And when they do so, the guidance that's given in Excelsior remains good law, in that the court is looking, at least in part, for conduct that was out of the norm. And one factor that was specifically considered in Lejeanbon was an order for indemnity costs where the background was a speculative or weak claim. So that was a relevant factor that the court looked at in Lejeanbon, but not automatically entitled to it, Excelsior remaining good law and authority. So that deals with Part 36 and other offers. I'm going to move on to deal with cost budgets. Now, I've highlighted the case of BDW Trading Limited and Lantoum, which some of you may be familiar with. Now, I could have highlighted a number of cases in truth, but the reason I've highlighted this is really to highlight the change to the rules, because it's the change to the rules which is probably of more application and consequence than the case itself. But dealing briefly with the background, the claimant in BDW Trading was a housing developer responsible for a housing development in Cornwall, and the defendant was a supplier of stone for that housing development. The claim, the claimant said, was regarding the substandard nature of that stone, and as a result of the substandard nature, the claimant said the properties required repair, and it pleaded those repairs at somewhere in the order of £5 million. So the parties had budgets approved. The claimant sought a revision to its budget for disclosure, and the disclosure was sought to be revised on the basis that the original budget had a express assumption that the claimant would be required to consider fewer than 50,000 documents. And as it turned out, the claimant was required to consider about 250,000 documents. Now, the claimant, in fact, put that to the defendant. The defendant, after some initial disagreement, eventually agreed, and they agreed with an increase to the disclosure phase, and the defendant also increased their budget to account for the increase in the number of documents. Now, the claimant subsequently sought a further revision, this time to witnesses and experts, and they said it was as a consequence of the increased disclosure, which had had a knock-on effect on those phases. Now, interestingly, in BDW trading, the pre-trial review in which these issues were considered came just one day after the changes to the rules, so CPR 315 and the introduction of CPR 315A. And so an interesting question actually arose in that case as to whether or not the rules applied immediately or not. The judge's comments, perhaps obiter, were that there was no transitional provision, and so the rules would apply immediately, albeit the judge said it probably didn't make any difference in that case, as both parties had agreed that the position would be the same on significant development under the new rules or the old rules. But at least it's interesting that that point was considered. The court, looking at significant development, highlighted this section, which I put on the slide, from the notes to CPR 3, highlighted that with approval, which is a fairly pithy description of a significant development. And I referred to the rule change, which the court had to consider briefly when looking at this issue. And the rule change here is the introduction of 315A. Many of you will be familiar with it. You will have looked at the precedent T format, which you're now required to use if you're going to vary a budget. And I wanted to highlight a number of points that it seems to be come out of 315A. The first point, and this is the final bullet point on the slide, resolves an issue that had caused some headaches at case management conferences and also for practitioners preparing cost budgets. And that was effectively whether or not one could seek a variation in respect of a significant development for which they had already incurred part of the costs of that significant development. And there was a case of Sharp and Blank, which effectively decided, albeit non-binding, that the point at which the cost management order is made is the point at which the incurred costs are at an end, and so anything after that date is future work, even if undertaken at the point of the variation being sought. And effectively that position has made its way into the rules now in 315A, which provides that the court may approve a variation even where the costs related to that variation have been incurred prior to the order for variation. So an important and useful clarification. But there is a potential trap, it seems to me, within the rules, which perhaps has not been given much attention, and that is the specific reference to promptness within 315A. And 315A now provides that budgets must be revised and submitted promptly. It seems to me there is certainly a possibility for a question to arise as to whether costs incurred prior to a variation which has not been made promptly, whether or not the new terms of 315A will impact upon the cost of that variation because of the requirement of promptness. So I highlight this case, as I said, specifically really to highlight the important change to the rules as much as the case itself. So that deals with a budget case. Now, fixed costs. I've chosen to highlight the case of Ryan and Hackett. Again, a number of people will be familiar with this case. An interesting case, it seems to me, on a difficult question. So the background to Ryan and Hackett, it's an RTA claim. It starts in the portal and the defendant admits liability. The claimant requests an interim payment. So far, so good. And the defendant makes the interim payment. Unfortunately, the claimant doesn't realise, for whatever reason, that that payment has been made. And the result of that is that they remove the claim from the portal process. And clearly in that case, it was unreasonable for them to remove the case from the process. The claim is subsequently issued, a defence is filed, disputing causation and quantum, and the case is allocated to the multi-track. We don't get as far as budgets, and the case settles for 20,000. Now, this was a case with an accident date of June 2013, and so the upper scope limit of the portal was 10 rather than 25,000 for this accident. So we had a settlement of about double the maximum upper scope limit of the portal. So the defendant's response is that the claimant should be limited to fixed costs. They say it's misconduct and it was unreasonable to exit the portal. Now, the claimant at assessment actually makes what may be considered to be an interesting admission or concession. They actually say it may be misconduct to exit the process in those circumstances, but they say the cost should not be limited to fixed costs. And the master actually agrees with the claimant. The master accepts that it was wrong for the case to exit, but he decides that that does not mean, in that case, that the claimant is limited to fixed costs, because his finding is that once it became clear to the claimant that the value of the case was significantly above the upper scope limit, they would have exited in any event. So that is the decision of the master on the basis of the information and evidence that the master had. And the case went off to appeal, and interestingly, it was heard by Justice Stewart, a judge with fairly impressive costs pedigree. And Justice Stewart found that the master's decision could not be impugned. Justice Stewart found there was ample evidence available to the master to make the decision that he made, and that decision was within his discretion. Now, of course, the decision in Ryan Hackett does not always mean that a claimant will receive more when they have exited from the portal process unreasonably. But what it does is provide an interesting argument as to the relevance of the post-exit conduct and how that might impact upon the question of whether the claimant should be limited or not, and interesting as well for Justice Stewart's finding that it was a decision within the discretion of the master. So that's Ryan and Hackett. I've chosen to highlight one other noteworthy case, and that's the decision in Ivanov. Again, many people will be aware of the decision in Ivanov, but it seems to me it's important in two respects. The first is that it makes clear, as with now a number of other SCCO cases have made the same point, that there is no cost order made when a Part 36 offer is accepted, which would entitle the claimant to proceed to detailed assessment. And that, in fact, the correct approach in such a case where it's a fixed cost claim is to deal with this by way of an application rather than service of a bill of costs. The second point that arises out of Ivanov relates to the court fee and the question of whether the claimant was entitled to the court fee despite the remission fee scheme not being used. And Judge Latham found that the court fee was still recoverable, and in essence, it had not been unreasonable for the claimant not to use the remission scheme. It's not a binding judgment, and so that argument may well see its way to a higher court at some point, but Ivanov is interesting as a at least fairly experienced and senior judge, again with a significant interest in costs looking at that particular point. So that's the decision in Ivanov. Now, I'll highlight one final case for you, and this case is on the issue of solicitor and client disputes. Now, many of you may not have dealt with solicitor and client challenges. I'll leave it to you and those who have dealt with them to decide whether you're the fortunate or the unfortunate ones who haven't had to face solicitor-client challenge questions. Certainly, these are difficult issues that arise and fairly novel issues that arise in solicitor and client disputes. And that is proven, it seems to me, by the decision in Belsner and Cam legal services. A fairly recent case, it came out about a month and a half ago, that sort of time period. And it's part of ongoing litigation that I'm sure many of you will be familiar with regarding challenges to success fee deductions in solicitor in cases funded by way of conditional fee agreements. Now, dealing with the background to Belsner and Cam, a fairly straightforward background. The claimant's injured in a road traffic accident claim. They instruct the defendant to bring that claim on their behalf. It's funded by way of a conditional fee agreement. And that conditional fee agreement provides for a deduction for the success fee and also for unrecovered costs. And the success fee is capped in accordance with the rules, but the unrecovered costs doesn't include a cap. So the result of that is that the conditional fee agreement, whilst limiting the success fee, does not have an overall cap, a point that is of some consequence in this decision, as we will find out. So the case is presented, liability is admitted within the portal, and the claim settles for about £2,000. The defendant deducts, the defendant here, as in the solicitor, deducts their 25% or so deduction from the damages, and the remaining damages are sent to the client. So all fairly straightforward so far. But subsequently, the client brings a challenge. They instruct a firm to challenge the deduction to the damages. And the firm contends on the basis of primarily or principally on the basis of the rule that is set out at the second bullet point to the slide, section 74.3 of the Solicitors Act 1974, they contend that the solicitors are limited to charging the client only what they can recover from the tortfeasor in the main claim. And as I say, they base it on this rule. And that rule provides in terms that in respect of any item relating to proceedings, except insofar as rules of court provide otherwise, the amount allowed may not exceed the amount which could have been allowed in respect of that item between party and party. So they rely on that rule. And that rule has found its way into the CPR 46, which deals with solicitor and client challenges. You'll find that in 46.9 subsection 2, and 46.9 subsection 2 provides that the section 74 limit will apply unless the parties have agreed in writing that the solicitor is permitted to charge more than can be recovered from the client. So, says the defendant, well, we have agreed to charge more because we've entered into a conditional fee agreement. And the conditional fee agreement specifically provides that the claimant is required to pay us not just what is recovered from the other side, but to pay a shortfall on that. And so on that basis, we're not limited to the amounts recovered inter partes. And the claimant says that's wrong because you have to have informed consent of the claimant to enter in to an agreement that provides otherwise for the purpose of CPR 46.9.2. And they say here there was no informed consent because what you didn't tell your client in the CFA is what the level of the fixed costs were and the subsequent effect that would have on the claimant's liability for that shortfall. And broadly, the judge, His Honour Judge, Justice Lavender, I should say, apologies, Justice Lavender, broadly agreed with the claimant on those points, finding that there's a fiduciary relationship between the solicitor and the client. And as a fiduciary, the claimant is entitled to the disclosure of all material information. And in this case, the judge found that it was material that the claimant was not told as to the extent of the shortfall or the fixed costs, and particularly because there was no overall cap in the CFA in respect of the deduction. And the judge remarked in Belsner that the absence of a global cap in the CFA was a striking feature of that conditional fee agreement. And when looking at the figures, the judge found that it was possible that the claimant at the end of the personal injury claim may have actually had to make a net payment to his solicitors because of the absence of a global cap and the potential for a shortfall. So it was on that basis that the judge found in favour of the claimant. Now, this is, of course, a very important decision for anybody involved in personal injury costs or practice. It has potentially serious implications as to the practice of the deduction of a success fee or shortfall from damages, and also as to the operation itself of the conditional fee agreement. We are expecting further decisions to come. There are a number of decisions that are currently up for appeal at various stages of the appeal process. And so it's expected that next year we will have further appeal decisions dealing with these issues. And we will also, it's likely, have a Court of Appeal decision coming in Belsner and Cam itself. There are a lot of unknown questions at this point as to when and if Section 74 applies to cases which are not issued. There is a serious question as to whether the solicitor and client do have a fiduciary relationship prior to entering into the conditional fee agreement, rather than simply after the conditional fee agreement. And there is a remaining question as to what extent informed consent can be said to apply to CPR 46.92. So lots of interesting questions to come on that point, and we should get those next year, as well as a potential appeal. So that deals with all of the cases that I wanted to highlight today. As I said, I've had to be selective. So it leaves me really to say many thanks for listening patiently to me discussing these cases. And of course, if anybody would like to ask any questions or has any observations that they would like to share, then I would, of course, be more than happy to listen or to answer anything that anybody would like to raise. But thank you very much to everybody for listening. Please do let me know if there are any questions. Okay, it seems there are no questions. What I can see a question actually that's come in here. So the question that has been asked, thank you, Victoria, regards to a form of words that would ensure that standard basis costs are awarded to a case pre-allocation. Now, there was a general observation that was made on that point in the cases that we've looked at. So in Hohenad Lake and Part 1, the court actually considered that point. And the point that was made is that the parties should be absolutely clear if they're settling a case as to whether or not fixed costs would apply to that case or not. So what we can say in Hohenad Laken, the Court of Appeal did not consider it sufficient to simply refer to standard basis. Similarly, it wasn't enough to simply refer to CPR 3613. So what is required is more than that. I don't think I could, or I should, probably advise on a specific wording outside the context of any individual claim. But the important point is that your wording will be absolutely clear. So if you do have that position, it seems to me that what you have to do is make sure you've set it out in writing with absolutely clear words. And just a second question from Adam, and that relates to circumstances where you don't have underlying proceedings. Would it be correct to have Part 8 proceedings and detailed assessment? Now, these are difficult issues at the moment, because it seems to me that there is somewhat of a lacuna in the rules as to how you deal with that particular point. But it strikes me that when one looks through the decision in Ivanov, and the interplay between the rules in CPR 36 and CPR 44, that it's not being anticipated that one will have costs assessed by detailed assessment when you're dealing with a fixed cost case, which leaves you still with an alternative by way of an application. And it's likely that if you don't have proceedings at all, you will have to make a request for Part 8 proceedings. And I would expect at that point, at least the parties to come together as to how and practically when can be assessed. And it may well be that directions can be agreed once you've dealt with it by way of Part 8 as to how exactly you can deal with the assessment itself. Damages-based agreement is the third question that's being raised. Damages-based agreements, well, do you believe damage-based agreements are potentially the way forward? Well, at the moment, of course, damage-based agreements aren't widely in operation, it seems, in personal injury. They are for a number of other areas, but when it comes to personal injury, it seems, at least anecdotally, that conditional fee agreements are still the proper approach for many people, rather than damage-based agreements. And there are a number of reasons for that, which is perhaps beyond the scope of this session, but certainly there is there is an issue with damage-based agreements, which is an issue that the rule drafters are going to, I am sure, look at and have been asked to look at over the next 12 to 18 months regarding the operation of those damage-based agreements and exactly how they can operate in a way that perhaps will be of more practical use to solicitors. So I think that is a difficult issue as to whether or not damage-based agreements are something practically in the future that's going to be of more application. I have to say, at the moment, it seems they simply haven't really taken off in personal injury. Whether or not that will change if the terms are made more advantageous, we shall see. Now I can see Thomas, did you perhaps have a question? I saw your mute go off, so I thought you might want to.
I did. I was just about to type it, but it's
no, please go ahead.
It's effectively on the Belsner decision.
Yeah.
Is the most telling feature that if you have a CFA in which the client's liability for costs is limited to those recovered on an inter-party basis, I presume then you wouldn't fall foul of Belsner, would you? It's the shortfall that causes the issue.
Yeah, so I think if your CFA was limited to inter-parties recovery, so if it was effectively a CFA light, then absolutely you wouldn't fall foul of the same point because you wouldn't have failed to give material disclosure as a fiduciary as to the extent of the potential shortfall. Yes, that's absolutely right. Now, there might be an issue, and this was something that wasn't really dealt with in Belsner. But if you look at the logic of the decision in Belsner as to the application of CPR 4692, the implication is that without informed consent, you can't charge your client any more than you can recover into parties. Now, does that apply to the success fee as well?
Yeah.
And arguably it does, albeit the difficulty, of course, there is that the judge in Belsner already had the Court of Appeals judgment in Herbert, which effectively had allowed a success fee in fairly similar circumstances. And so it seems to me that there is an unresolved tension between the decision in Herbert and the decision in Belsner, which may become a relevant factor. But in principle, yes, I agree with you that Belsner will not really bite if you have a CFA light limiting you to inter-parties recovery.
That's great, thank you.
Okay, I can't see any other questions. One final point perhaps I'll make is I know that there are a number of members from Kenworthy's civil team that are in attendance. So if any of those members do have any observations they'd like to share or anything of that nature, please do feel free to do that if you would like to. Fine. I'm going to take that as a no for any observations on those cases. So it really just leaves me to thank everybody for attending. Thank you for the questions. Of course, if there are any issues that arise and you would rather discuss them in person or by email, please do get in touch. I'm always happy to discuss costs. So thank you very much for attending, and I hope everybody has a good evening. Thank you.
Thank you.